Hey everyone, it's the eagerly anticipated Lecture 4 covering the remainder of the U.S. Constitution. We talked about the Bill of Rights last week. We're going to talk about the remainder of the Constitution, the other amendments, the various articles, that sort of thing. Change the scenery today. I'm coming to you from a ski chalet in West Virginia. My wife and kids are out skiing. I don't ski because I didn't ski as a child or young adult. And I feel like at 42, this is not the time to be really, really embarrassingly bad at something. Also, I have foolish Texas pride, so I'd be like, green trail, blue trail, black trail, whatever, I'll do it. And I would die. I would literally just die out there because I'm stupid. So that's why I'm up here with you today instead of skiing. So let's get started. So let's talk about the structure of the Constitution here. So it's largely comprised of three parts. There's the preamble, which is basically sets forth the goals and purpose of the Constitution. And I gave you a component of that at the beginning of the class. We identified that as sort of the core values of kind of what the United States represents. There are 7 articles that lay out the structure of government. So we'll cover those here. And then there are a total of 27 amendments. So there's the 10 Bill of Rights amendments, and then there's 17 additional ones. So we'll talk about that. Those sort of represent changes over time. So the first 10 came in sort of in one fell swoop, and then you've got over time the addition of other amendments here, and we'll cover those too. So let's start with Article 1. This concerns the structure of the legislative branch of the U.S. government. So it's talking about Congress here. Specifically says the legislative branch will be bicameral, meaning that there will be 2 chambers. That's how we get the House of Representatives and the U.S. Senate. When we talk about the legislature, we'll discuss that more here. Mentioned specifically that the vice president will serve as the president of the Senate. Without voting power unless the Senate is sort of deadlocked. So recently here, the Senate has been, pretty sort of close and tied. And in fact, a long time we thought it was going to be tied while some races were finishing up this last time. In the event of a tie, then Vice President Kamala Harris has the tie-breaking vote. So that essentially in this situation would benefit, obviously, the Democrats. House members have to be at least 25 years of age to be in the House. The senators have to be 30. The legislature is the sole institution in the U.S. government that can impose impeachment powers. So it can remove a federal official from office, such as the president or a judge, and we'll talk more about that too. It also states that every potential bill should pass both chambers. So when we go through the legislative process, we'll talk about how the House and the Senate both have to agree on legislation before it goes to the president for it to pass. And it gives the power of Congress to override a presidential veto by a 2/3 majority vote in both chambers. So when we get to legislative politics again, we'll talk about how the House and Senate can pass a bill. The president can veto it and say, no, we're not going to pass that. If the House and Senate both have a 2/3 majority vote to override that veto, then they can do so, and the bill becomes law. So let's talk a little bit more about the powers of Congress. So some of these were detailed when we discussed the enumerated powers of the federal government during our piece on federalism here. So we talked about lay and collect taxes, borrow money, regulate commerce. So again, there comes the Commerce Clause. Some other things: establish a post office, fight pirates. So yeah, obviously it's you're not going to be members of Congress out fighting the pirates or their children. It's going to be you and I and our kids and that sort of thing. But this was very important at the time that they were drafting up Article 1 here. You also have this piece here: to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, so everything that had been mentioned up to that point, and all other powers vested by this Constitution in the government of the U.S. Or any department thereof. And so the duck is not going to let me get away with that. He said, wait, you just slipped the necessary and proper clause in there thinking I wouldn't read it. Doesn't it basically give Congress sort of unlimited power here? The duck would not be the only one that sort of thinks that. So that last little bit that I read you there is the necessary and proper clause. It says, Congress has the power to do what they need to do to, govern these United States. Critics have long suggested that this has basically given a blank check to Congress to essentially take over power from the states and from the people and to sort of execute their authority, their federal authority in matters that should be reserved to the states. Obviously, we saw this during the COVID-19 pandemic, where you had state governors who were trying to ban mask mandates or ban companies from firing people for not getting vaccines and that sort of thing. And Congress, well, not even specifically Congress, but the executive branch stepped in and said, nope, this is falls under the necessary and proper clause. This is federal. We run the show. So, again, it's a function of federalism, and it's this ongoing debate here of, where the power is delineated. Is it the states? Is it the federal government? Is it the people? And some iteration kind of thereof. So Article 2 deals specifically with the executive branch or the presidency here. So a few things that Article 2 says: the presidential term is for 4 years, requires that the president be at least 35 years of age and a natural-born citizen. And what that means is that they have to have been born in the U.S. or a U.S. territory or on a U.S. military base, for instance, to be considered, a president. Or, a natural-born citizen would also be somebody who is born overseas to American citizen parents. Would be an example there too. If you were a citizen of another country and then you gained your citizenship in the United States, that wouldn't qualify you there. Names the president as the commander-in-chief of the armed forces, so he is the head person. He or she, if we have a female president, will be the head person over the armed forces, and the military leaders there respond to the president, and that's done specifically to avoid obviously a military coup, because particularly if you go back hundreds of years ago, you had military generals that were quite powerful and had a public following. You still actually see this in South America and a lot of Latin American countries today, and so that was a concern that sort of drove that. The president has the power to nominate and appoint federal justices and officers, although with the Senate, with approval of the Senate. So we'll talk about that later on too. The Constitution specifically says the president has to provide a State of the Union update. Now, the interesting thing is the State of the Union wasn't a formal speech for most of U.S. history. In fact, it wasn't really until the innovation of radio that the president decided to make it a speech and that it was nationally broadcast. It used to be essentially a letter that the president sent to Congress. He didn't even deliver it himself here. So obviously, this has become more of a spectacle over time, and it gets more news coverage and more press and that sort of thing. The Article 2 specifically mentions, the president can be removed from office on impeachment grounds for a conviction of treason, bribery, or other high crimes and misdemeanors here. So the few times where we've had an instance in my lifetime, at least, that a president has been impeached, the impeaching authority has had to be able to show really that kind of high crimes and misdemeanors is the big, sort of piece that's been relevant there. So let's talk a little bit about presidential impeachment for a moment. So the House can vote by a simple majority to formally impeach a president. An impeached president must be convicted by a 2/3 majority of the Senate, however, in a trial that's overseen by the Chief Justice. And so think of the House impeachment process as more or less an indictment. It's the House investigating the president and determining that there's sufficient evidence to suggest that a violation of one of those things we just mentioned has occurred, and so then they send that up to the Senate. So the Senate conducts a trial. Not a traditional trial because the jurors already probably know how they're going to vote before it even starts. But the Supreme Court Justice, Chief Justice of the Supreme Court oversees it. It does require a 2/3 majority in the Senate. Now, as we'll talk about here in a second, these are often very partisan efforts here, so it's a very difficult hurdle to overcome. There have been 3 impeached presidents, 2 in my lifetime and some of yours. Andrew Johnson was impeached and acquitted in 1868. Then we have Bill Clinton, 1998. He was acquitted in 99. That was my graduate of high school in 99. That was a big deal there. That was the whole Monica Lewinsky affair. If you're not familiar with it, Google that and you can read up on it. Actually, the charge was perjury, essentially, that Clinton, in testifying in a civil matter, had that had basically lied under oath was the charge there. He was impeached in the House, but acquitted in the Senate. And then Donald Trump has more recently been impeached, actually twice, in 2019 and 21, and was acquitted in both times, both in 2020 and 2021, due to a lack of the Senate being able to get a 2/3 majority vote there. All right, so the duck's back. He says, "Isn't the impeachment process just a show of partisanship?" Seemingly it can be, although there are other examples where maybe it's not. So Richard Nixon, for instance, if you're familiar with the Watergate scandal, there was evidence that he had ordered tampering against the Democratic Party to basically steal inside information, and had basically ordered, operatives to break into the Watergate hotel. It became clear during that process that not only was the House going to impeach him, but based on speaking with and polling members of the Senate, he was most likely going to be convicted in the Senate too, and that would have been a fairly bipartisan effort with both Republicans and Democrats joining together to do so. And so to avoid that, he actually resigned. That was really the reason for that. So you could point to that and say, look, that probably wouldn't have been a partisan sort of process here. But if you look more recently, Bill Clinton was impeached on 2 articles, and it was pretty much a partisan vote under a Republican majority House. Every Republican in the Senate voted to convict him. Actually, a handful of Democrats actually joined as well, but it fell well short of that 2/3 majority. Trump's first impeachment was an entirely partisan affair. The second one, actually, several Republicans crossed party lines to vote to impeach on that one as well. So Article 3 discusses the federal judicial system, so the third branch of our government here. Article 3 specifically says you need to create a Supreme Court of the United States, and then you need to create a structure of lower federal courts underneath of the Supreme Court. Here in a couple of weeks, we'll talk specifically about the court, and I'll sort of lay that out, kind of how that structure works there. One of the things the Constitution says is that justices serve for life, so as long as they're not impeached. That'll be another sort of important point, and it's a really sort of fascinating piece on U.S. government that, again, when we get back to the Founding Fathers and some of those original ideas, they were very concerned about the public having sway over the judicial process. There was very much a belief that matters of justice should not be decided by voters. And so to ensure that, they made sure that federal judges were appointed for life, meaning that, if they issued unpopular rulings, they couldn't be removed and thus otherwise unduly influenced by, public opinion or pressure from members of Congress, that they could be free to interpret the Constitution based on, its interpretation and how they see it there. So we'll talk more a little about that later. It also establishes the standards for treason, essentially levying war against the United States or giving aid and comfort to its enemies. We'll talk more about that on the next slide here. Interestingly enough, there's some fun facts here, things that aren't covered in Article 3. The size of the Supreme Court. So it's mostly been 9 justices. You've heard, particularly after last summer's events, there were some musings from, the Biden administration of the potential of increasing the size of the Supreme Court, which could easily be done, and you could keep doing that over and over again. And, obviously that would be a mess. So far it's been avoided. Interestingly enough, you do not have to be a lawyer to be appointed to the Supreme Court. The Constitution doesn't say you have to be a lawyer. So technically, you can be appointed without, being a lawyer. And I believe it's happened once. I need to go back and look this up, where that's happened, but it's obviously pretty rare. Fun facts on that, on those grounds. 4 U.S. states actually allow you to take the bar exam and become a practicing attorney without actually going to law school. California, Virginia, Vermont, and Washington. They do require an apprenticeship. So actually a family friend of mine, like way back in the day, really from my childhood, was a paralegal in California for many, many years, grew to develop an expertise in the law. She apprenticed under the attorney she was working for formerly, went and took the bar exam, passed it, became an attorney with no law school there. So kind of a neat deal. Article 3, again, so I mentioned these matters of treason here. So I want to talk specifically about treason, sedition, and insurrection. And when I was teaching this class 10 years ago, I was like, when is this ever going to come up? And lo and behold, here we are. So the thing about treason, and oftentimes after events such as, the January 6th insurrection, you'll hear, talking heads on TV and stuff will talk about treason, or publicly on social media, people talking about treason. Treason is actually a wartime crime. So it's very important to make this distinction here. We would have to be in a declared war against a declared enemy. And then if you were aiding that enemy, so for instance, there was a young man from California named John Walker Lynn. several years ago, was captured while fighting with the Taliban against U.S. forces. He was charged, essentially and convicted of treason as a result of that because they were declared enemy. So the events of January 6th didn't amount to treason, and that's why you don't see treason charges. Now, what they can and have been charged for and increasingly convicted for is sedition. And insurrection. So sedition specifically, doesn't have to occur during a time of war, although it can. It takes essentially 2 or more people to conspire to either overthrow, put down, or destroy by force, the U.S. government or wage war against it, or to forcefully oppose the government authority, preventing, hindering, or delaying the execution of laws of the United States. The third grounds there is seizing, taking possession of any U.S. property contrary to the law. So when these, men and some women were storming the Capitol, they were, in a lot of cases, explicitly doing so on the grounds of stopping the vote to acknowledge Joe Biden's election. And really, again, it's like so many things, a lesson in social media etiquette here. Don't film yourself saying, we're going to stop that election, and then don't follow it up by filming yourself stealing stuff out of Nancy Pelosi's office, because it's in the Constitution. This was one of the areas interesting if you read legal opinions, because sedition is so rarely ever, is someone charged with it. But a lot of legal scholars going, after January 6th said, yeah, this is pretty clear cut in a lot of these cases here. So you've seen members of the Oath Keepers group, and then increasingly there's more talk of members of the Proud Boys, which is the white nationalist organization, potentially facing these charges here. Insurrection differs in that it requires actual acts of violence against states or its officers. So, for instance, you would see people during the January 6th riots attacking officers, but they may not have been a part of a seditious conspiracy, right? They may have just, shown up because they knew people were going to be there, got caught up in the moment, threw a barrier at a cop or something like that. A lot of them have been charged on charges of insurrection. So Articles 4 through Article 7. I'll just skip over this pretty quickly here. Article 4 gives Congress the power to decide whether new states are allowed. Codifies that states must transfer fleeing suspects to the state where a crime has allegedly occurred. So, California might not want to send a prisoner back to Florida for extradition due to sort of political battles between the governors, but the Constitution specifically says they have to here. And says the federal government must defend each state. So if, the French decide to attack, let's see, Delaware, pick on Delaware again. The U.S. government can't say, it's just Delaware. We'll see how it goes. They actually have to defend it, and the Constitution, Article 4, lays this out here. On that point of statehood here, so this is interesting because there has long been a push for statehood for Washington, D.C. So Washington, D.C. is comprised of about 700,000 Americans that actually don't have voting representation in Congress. So even though, D.C. essentially has non-voting members of the Senate and House of Representatives, actually of the House of Representatives, not of the Senate. So the argument has been made that, it's taxation without representation. We pay the same federal taxes, but we don't actually have voting representation in Congress. This is something that has been proposed in the House for a couple of years. Actually, I just read it's going to come up in the Senate again. It has consistently been stopped in the Senate, and it's been stopped with the threat of a filibuster, and we'll talk about this too. It has essentially been, and not to pick on Republicans, but this is the way it's been Republicans that have consistently been opposed to it, because if you think about it, it makes sense for them and their electoral strategy. That would give Washington, D.C. 3 electoral college votes. And we'll talk more again about the Electoral College here. And being a state that is essentially exclusively an urban area, it would lean very left in Democratic favoring. So they don't want to give Democrats, 3 Electoral College votes. And so that's why they've historically opposed this. Article 5 specifies how amendments can be added to the Constitution. We talk about that here shortly. Article 6 states that members of Congress must swear an oath to the Constitution. So if you have family or if you served in the military when you took that oath of office, that's where this comes from. Article 7 sets that 9 states were required to ratify the Constitution. This was, obviously during the initial Constitution. Now we have, more states and, 9, need more than 9 to get things done there. Skip through some of the other amendments real quickly, but we're going to revisit some of these here. Amendment 11, 1795 makes states immune from lawsuits by out-of-state or foreign residents. So I live in North Carolina. I can't, sue the state of Florida because now I live out of state. 12th Amendment, 1804, requires the president and vice president to run together on a single ticket. So prior to 1804, actually, and you see this in the early, presidents and vice presidents, you have, two from different parties, because that could happen prior to 1804. 13th Amendment, we didn't get another amendment for 60 years here. 13th was kind of a big one. 1865 abolished slavery here. But the challenge with this is that, so we abolished slavery, and then in the Reconstruction South, you had a lot of laws passed and a lot of actions carried out that essentially, didn't allow slavery, but were creating injustices and inequalities purposely and sort of codifying discrimination. And so then you see a series of amendments that are specifically dealing with that. So 14th Amendment here, which is a huge one, we'll talk about in a second. 1868, so it's 3 years after slavery is abolished, defines citizenship and clarifies due process and equal protection here. The idea being it was explicitly state that former slaves were in fact citizens of the United States and were due process and equal protection of the law there. 15th Amendment, 1870. Prohibits the denial of right to vote based on race and color. Again, you had Jim Crow laws go into effect, where you had things such as literacy tests, things that disproportionately affected poor blacks in the South and former slaves residing in the South here. So the 15th Amendment tackles this. Then we get a little bit of a break. You got the 16th Amendment in 1913 allows Congress to levy an income tax without having to distribute it equally. So the federal income taxes that we pay are not distributed to different states equally. In fact, it's quite unequal, and you can go through a rabbit hole of the internet to find out how that is. It's quite interesting. How that rolls out. 17th Amendment was same year, changed Senate elections to direct elections by voters. So another big one here. So today we vote every 6 years for each Senate seat. But interestingly enough, prior to 1913, that's not how this was done. In fact, the original intent of the founders was that the Senate would represent the interests of business owners. And so that's why state legislatures actually voted for the two representatives of the Senate for each state. This didn't become the purview of the public until 1913. And then 18th Amendment here, 1919, prohibited the sale of alcohol within the United States. So you couldn't sell any liquor, booze, wine coolers, those, God, what are those crappy, you know what I'm talking about, the barely flavored waters that are alcoholic that you young people for some reason like. I don't understand. Not all of you young people, I'm sorry. Anyways, those two, all those didn't exist at the time, and could just as soon not exist now, and that would be fine too. But I digress. Let's go on to the other amendments here. 19th Amendment prohibits the denial of vote based on sex. This, the 19th Amendment, passed in 1919, but ratified in 1920, gives women the right to vote. So it, allows this, and I'll talk more about it in a second because this actually has an interesting sort of historical, sort of basis as well. 20th Amendment, 33, sets the date the president takes office after the election. 21st Amendment, 1933, they decided prohibition wasn't such a great idea after all, and they repeal it. 22nd Amendment, 1951, FDR was elected to 4 terms. He didn't live out his 4th term there, but some, particularly Republicans in power, didn't want that to happen again. They saw it as being too much akin to basically too much power given to one person and creating a de facto monarchy. And so they passed this amendment saying that the president can only serve 2 terms. 23rd Amendment, 61, so we have another little bit of a break. Gives D.C. electors in the Electoral College. So I apologize. I was mistaken earlier when I was saying, because my mind is blanking here. D.C. does have electors in the Electoral College. They don't have votes in the House and the Senate. So they do get to contribute. But the major grievance against, as I talked about, Republicans not wanting DC to have representation in Congress, voting representation in Congress, is that those are traditionally liberal voters in that major urban area, and so it wouldn't sort of benefit them. So they have decided to historically to go against that there, and it, like I said, kind of makes sense. But I was mistaken earlier when I said that DC actually does have electors in the Electoral College as of 61. 24th Amendment prohibits taxation requirement for voting again. So this is during the Civil Rights era where you see a few pieces come out here, or a few amendments. There were basically requirements that you had to be paid up on your taxes, which many poor people weren't necessarily in that position. Again, it was a poll tax, essentially a Jim Crow era style way of, particularly in the South, of disenfranchising, particularly poor, but also particularly black voters. 1967, so this is right after the 25th Amendment, right after the assassination of John F. Kennedy, when we realize we need to make it pretty clear the succession of the presidency, and so that sets forward those rules. 26th Amendment, 71, set the federal standard voting age of 18, so prior to that, states could decide what they wanted their voting age to be. 27th Amendment, 92, so that requires congressional pay raises to be implemented in the following term. So when I talked about that original Second Amendment that got scratched, this is actually where it gets brought back up in 92. Okay, so a lot of amendments there. Let's talk about amending the Constitution and how it works, because it's not easy to do. That's why it's only happened, the essentially 17 times since the Bill of Rights was adopted here. Adding an amendment to the Constitution first starts with an amendment being proposed, and it can be done so by one of two ways here. So you can have a 2/3 majority of vote in both the House and the Senate to propose an amendment here, or you can have a constitutional convention called for by at least 2/3 of state legislatures. That has never happened. The only way amendments have ever been suggested or proposed has been through the first method there. It is interesting, though, because Florida Governor Ron DeSantis right now is leading an effort and going around to many different states to push for a constitutional convention to essentially term limit members of Congress from serving sort of indefinitely there. So that's something you may read about. The amendment, does not go to the president for approval. So the president actually isn't involved in the constitutional amendment process at all. And the Constitution explicitly forbids him or her from being a part of it. It is sent to either the state legislatures or a state constitutional convention for ratification. And so you essentially need 3/4 or 38 of the states to agree to the amendment for it to be added to the Constitution. Like I said, it's very difficult to do, as you might imagine. And it may become, I've read a lot about this recently, where it might become a little bit more viable in recent times, because Republicans have extended so much power in state legislatures, even in places that aren't necessarily very conservative. They've done so through redistricting and drawing the maps, and we'll talk about that, strategically. We'll talk about that more in the future here. But they've gained power in state legislatures, which may give them, it's still going to be kind of difficult to get 3/4 majority. Again, the founders wanted to make it very difficult to amend the Constitution because they saw this, obviously as the supreme law of the land, and there had to be a certain level of agreement here. Screen grab from the right there. If you were a kid in the 70s or even actually in the 80s, I remember watching Schoolhouse Rocks video clips there, educational clips. So your teacher would roll out the big cart with the TV, the giant tube TV, and the VCR, and throw that in there. Dating myself a little bit here. You need a code word, Schoolhouse Rocks, that 70s era PBS style educational program on U.S. government. Schoolhouse Rocks. Give me that for your code word, and you will get the attendance credit. So let's talk about some big freaking deal amendments, essentially, and we'll go through a few of these that I covered just briefly that are particularly important. So obviously, 13th Amendment here says that neither slavery nor involuntary servitude, except as punishment for crime after being duly convicted, shall exist within the U.S. or any place subject to its jurisdiction. So end slavery here. The 13th Amendment was a direct byproduct of the Union's victory in the Civil War. In that reconciliation effort. So big picture here, the North wins the war. The South wants to rejoin the Union here. The North says, okay, but you're going to have to support us in voting these amendments, namely to end slavery and then a couple other ones here. Still, the 13th Amendment only barely passed the House with a 2/3 majority there to essentially become an amendment that was considered for ratification. And then it was really pulling teeth to get the southern states to ratify the 13th Amendment. Again, it was done so with the threat that they would essentially never regain representation in the federal government again if they didn't. So this was essentially the spoils of victory. And if you want to make a direct connection to the Civil War and slavery, because some people like to write it off and say, well, it wasn't really about slavery, it was about states' rights. One of the first things they did after they won was pass 13A to ensure that it was codified in the Constitution. Similarly, 14th Amendment here. So this is a huge one, and this is probably one of the most litigated amendments in the Constitution, at least in contemporary times here. And basically it establishes two things, the Due Process Clause and the Equal Protection Clause. The Due Process Clause that says that the government cannot deny a person liberties without a due process. So you can't be, as a U.S. citizen, for instance, jailed indefinitely without, a hearing in a trial. We can do that to non-U.S. citizens, and we've done it in Gitmo, which is a major source of criticism for enemy combatants during the War on Terror. But for as a U.S. citizen, you have rights to due process here. It gets a little tricky when you're talking about immigrants, and my wife's an immigration attorney, and she can speak more about that as they're not citizens, and so there's certain due process and other things that don't happen. And then, more importantly, the Equal Protection Clause here requires that the law be applied equally to all persons. And so the reason for the 14th Amendment, again, to go back to that, was that after the Civil War, you had a lot of states that said, fine, we'll ban slavery, but we're going to create all these other laws that are going to make life really hard on newly free African Americans. And so the 14th Amendment was an effort to ensure that, newly freed slaves were given equal protection of the law as any other citizen. There's a couple of cases here that are important to know with regard to the 14th Amendment here. The first one is Plessy v. Ferguson, 1896 here, and that dealt with racial segregation. So you had, Plessy actually was an African-American gentleman who was violated Louisiana law, by prohibiting black rail car. Actually, Plessy was not the African-American individual. He was prohibiting African-American riders from riding in whites-only cars. There was a lawsuit. The Supreme Court actually ruled that separate but equal was okay. We call this a separate but equal doctrine here. Said that as long as both rail cars were comparable, that this was fine. They said that, if the African-American, black-only rail car had benches and the whites-only car had cushy seats, that would not qualify here. That was the law of the land for about 50 years, or more than 50, almost 60 years, until it was overturned by the case you may have heard of, Brown v. Board of Education here. So Oliver Brown was a gentleman. His daughter was banned from attending a school near her home, which was a whites-only school. She was forced to ride a bus further to a segregated black school there. Now, in the case of this, the Board of Education here, the school district said, look, both schools are equal. The court here overturned the Plessy v. Ferguson ruling and said that anytime you have separation, particularly based on race, it is inherently unequal and thus a violation of the 14th Amendment. So that was when a really interesting time in U.S. history where you saw resegregation of schools, and the impacts of that are still being felt today, particularly in the American South. But it was a very contentious period there based on the Supreme Court case. And again, it all comes back to federalism. You had states that were threatening not to enforce it. And so federal troops, essentially the U.S. military, had to go to many of these southern high schools and schools and essentially escort black children to school because you had, particularly southern governors who were fighting against this and claiming they weren't going to allow segregation there. So a very difficult and, very disturbing time in our history. 19th Amendment here, the right of citizens. So again, this was allowed women the right to vote here. So here's a fun fact about history. Women actually largely had more voting rights prior to the U.S. gaining its independence. If you go back to the colonial eras, voting rights are more based on land ownership. So if you owned land, you had the right to vote. Well, a lot of times what happened is that men died before their wives, and the wives were widows, but they inherited the land and thus became the landowner and thus gained the voting rights. So in many places in the country, actually, women had been voting for quite some time. It wasn't until, it's a tragic sort of story in this history, this history of American freedom, from the British, but now women can't vote. And interesting too, there wasn't a lot of objection to women voting until a little bit further on in our history, and it sort of got tied into evangelical sort of religious notions of gender distinctions in at the home and in leadership and in positions of power here. So actually, that's an area where historically women saw their rights kind of go away here. But the 19th Amendment actually restored this. Prior to this, women had made the case that the 14th Amendment, equal protection, should essentially apply to them as well, but the courts largely sort of disagreed here. Some of the things that were going on during this time period. So prior to World War I, there was very much a public sort of movement against women, having positions of power and being in the workforce and earning their own salaries in these things. But World War I sort of forced the hand because so many U.S. soldiers had gone overseas, and this was during the boom period of the Industrial Revolution in the U.S. So we needed more workers, and women filled a lot of those roles. They did so in World War II as well here. So 1981 ratification, 1920, and it was principally many former Confederate Southern states where you saw opposition there. Okay, another visit from the Duck. He says, haven't women historically been the principal impediment to equal rights for women? Wow, you're trying to get me fired here. Sort of, but not really. So here's the thing, right? So if you assume that the population of adults in this country is 50-50, give or take, it's not quite correct. There's actually more women because men die younger, unfortunately, or fortunately, depending on how you look at it. I lived in Tampa for a lot of years and did a lot of demography work there, particularly as it related to people that flew. And being a community that has an older age cohort there, you start to see that gap. So when you get above about 80, there's a pretty big split between men and women because women are living longer there. Anyways, so if you assume this, and you assume historically that the vast majority of men are going to vote against, passing equal rights onto women, which historically, was very much opposed by men, then it really only takes a small portion of women to, be the deciding vote, right? So if 5% of women, oppose this, and that gives us a 55% majority there. So while women have traditionally overwhelmingly supported equal rights for women for the most part, you've had small groups of women, particularly in the South, historically, traditional evangelical oriented women and matriarchs of those families have opposed this out of a preference for a more traditional sort of gender distinction in work and in families and elsewhere there. But that largely, stayed, and that contributed. That's the reason the Equal Rights Amendment failed in the 1970s. Again, it's not correct to blame it on women, but to say that women weren't able to get the cohesive support that men sort of did, kind of in their opposition there. One more here to cover, of course, the 21st Amendment reads, well, you can read it there, but that's not actually what it says. I just made that up. It ended prohibition. So prohibition really sort of fell under, wasn't particularly favorable. People were starting to realize that, it was costing a lot of money to break open these like speakeasies, and arrest all these individuals, and it just wasn't working. People were still finding a way. You have, obviously the moonshine era there, and eventually, due to public sentiment and popularity, the 21st Amendment repealed the 18th Amendment here. Although interestingly enough, several states actually maintained prohibition at the state level. In 1966, Mississippi was actually the last to rescind its law, found that unattractive people weren't able to procreate, and so they needed to bring back alcohol. That's not true at all. I just made that up. But again, so it's important to note, too, that even though the 21st Amendment repealed the 18th, it didn't necessarily give Americans the right to drink. I grew up in a place where you couldn't, I lived in a dry county in Dallas County, where you couldn't purchase alcohol except for sort of small areas of town that were zoned for alcohol, and they were in bad areas, and so you wouldn't want to go there anyways. So my parents, that's probably largely the reason my parents didn't drink is because it was actually really difficult. You couldn't even buy it in restaurants without joining a club. This was like a really weird thing that when I explained this to my wife, who's from Ohio, where everybody drinks all the time, she finds it very unusual. But just to drive home the point that there's still some local control there. So that's it. 39 minutes here. I'm kind of exhausted, but that is the remainder of the Constitution, sort of in a nutshell. The next 3 weeks we're going to spend on Articles 1 through 3, and specifically the institutions they create there. So we'll talk about the legislative, executive, and judicial systems, and that'll take us into the midterm exam. So I hope you enjoyed this. I know it was a long one, but a lot of good information there.